Is the Sex Offender Management and Treatment Act unconstitutionally depriving sex offenders of due process rights? To find out, you have to read People versus Toulon, but it's 33 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Toulon. The citation for this case is 2024 New York Slip Opinion 05178, published by the New York Court of Appeals on October 22nd of 2024. The issue in this case is whether the Sex Offender Management and Treatment Act is unconstitutional in a due process violation for failing to allow an adversarial process before the 30-day mark for recommitting someone into civil confinement. To understand and appreciate the context of this case, the background that's helpful to know is first that the 14th Amendment of the United States Constitution and the 5th Amendment of the United States Constitution promise that before the state can deprive a person of life, liberty, or property, they have to provide due process. Due process clause requires that due process be provided, which at a minimum requires notice and an opportunity to be heard before depriving someone of life, liberty, or property. The other thing you have to know is the SOMTA statute is a little complicated. I'm going to try and make it easier and more simple. But the Sex Offender Management and Treatment Act system under Article 10 of the Mental Hygiene Law basically is designed where if someone is a sex offender, if someone's committed a sex offense, a criminal sex offense, they're evaluated before they're done with their incarceration by a psychologist. They're given a psychological evaluation. And if it's determined by that psychological evaluation and the case management team that the person has a mental abnormality that makes them more prone to commit sex offenses, they'll refer the case to the Attorney General, who can then file a petition to have the person civilly committed, not criminally charged or put into jail. It's civil commitment in sort of a hospital setting where the person will be held because they're too dangerous to be on the streets, that they pose too much of a risk to society because they have this dangerous brain abnormality that makes them prone to committing acts of sexual offense. Once they're civilly committed, after a jury trial and after the judge determines after dispositional hearing that they have to be civilly committed, they're reevaluated periodically to see if they're still too dangerous. And if they're determined to be not too dangerous to be in the street, they're released onto the street with parole conditions that can include GPS conditions, alcohol monitoring, polygraph examination, things like that. And if the parole officer, after they've been released from civil confinement, finds that they are still a danger or that they should be recommitted, they can alert the Attorney General, they can scoop them up and put them in jail, waiting the outcome of this proceeding. And the Attorney General can file a petition, and within 30 days of the filing of a petition, that's when a hearing where the defendant has a chance to confront the accusations against him. But it has to be within 30 days. And sometimes if there's adjournments, it can be 5 months or a year before that actual adversarial hearing takes place. Okay, that's the background, a lot of background. What are the facts in this case? The facts are that in 2006, Ralph S. was convicted of first-degree sexual abuse and sentenced to a period of incarceration. He was evaluated under that SOMTA statute, found to have a brain abnormality. They do a whole jury trial. The jury agrees. A judge civilly confines him. He's released back to the community. He's released back from the community from civil confinement with conditions that include, like we said, GPS monitoring, alcohol monitoring, etc. His parole officer concludes during one of his visits that the defendant, that the respondent here, the sex offender, has been tampering with his alcohol monitor. So he scoops him up, puts him in jail, alerts the Attorney General, who files a petition. And in that recommitment process, the Attorney General has to file a petition with the court, ex parte, meaning by themselves. The defendant doesn't have a chance to respond. If the judge agrees that there's been probable cause to believe that a violation has occurred, now they schedule it for that hearing, which has to take place within 30 days of the filing of the petition. Ultimately, it takes 5 months before the adversarial hearing takes place because there's adjournments, there's different psychological evaluations that have to take place, and the defendant moves to be released under a habeas petition saying, you got to release me, I'm being held unlawfully. The Supreme Court denies it. The Appellate Division also denies it. And ultimately it goes to the Court of Appeals. And the question on the Court of Appeals is this statute, is this whole system unconstitutional? Because it doesn't let the defendant rebut his accusations until the adversarial hearing, which can take place within 30 days, but could take place 5 months later, as it did for Ralph S. Now, the Court of Appeals evaluates this and says, first of all, there's a strong presumption that legislation is constitutional. Okay? We have a strong presumption of constitutionality. And they say there's a test that we got from the Supreme Court in 1976 called the Matthews versus Eldridge test. It's a balancing test. It's got 3 parts. Number 1 is the private interest of a litigant. Who does it weigh in favor of? Is the risk of erroneous deprivation and the absence of substitute procedures? Who does it weigh in favor of? And is the state's interest in avoiding additional procedures? Who does it weigh in favor of? So the respondent, the sex offender here, says, I want an adversarial proceeding earlier than the 30 days that the statute requires because it violates my constitutional rights. And when the Court of Appeals assesses each of these 3 factors, ultimately they say the private interests are in favor of the state because the defendant has diminished liberty interest because he's already been found to have this brain abnormality. With respect to the risk of erroneous deprivation of civil liberties, they say it's low. The risk is low. Why? Because there's already an ex parte application being presented to the court. The judge isn't being involved as to whether it's probable cause. And so that's sufficient. And with respect to whether the state has an interest in avoiding the high bar of additional procedures, they say that's that's in the state's favor because this could pose a risk if you require the adversarial proceeding to take place before any deprivation of civil liberties. So there's a 5-2 split decision here. The Court of Appeals says the SOMTA statute is valid. It's not unconstitutional. It does not deprive sex offenders of their due process rights. But there's a strongly written dissent here by Judge Rivera, joined by Judge Wilson, that says liberty interest is liberty interest. This person has already done their time. Just because they have a brain abnormality, they've been declared to be safe for the community. To take away that right and put them back in should require an adversarial proceeding before the 30-day mark, or in this case, the 5-month mark. And that's the case of People versus Toulon. The SOMTA statute is constitutional. It does not violate sex offenders' due process rights. That's the holding. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.